diagram SG number 1234/2020, hereinafter referred to as the premises. Now, therefore, the parties agree as follows. So do you see what you have to do? You now describe the property as the property, you give a description of it, and the portion that is being leased we call the premises. And you make reference to the diagram. Which diagram is annexed? Here too. Don't forget to say that. And here too is to your lease. And obviously you're going to annex, you probably will have sufficient copies to annex to both copies that both grosses, each gross that you lodge at the deeds office. All right. So in the instance when you're leasing a portion of the property, you've got to lodge the gross in duplicate, don't call it the gross, you just call it a notarial lease in duplicate, your diagram of the leased portion, as well as your title deed property. What you keep in your protocol is the minute with the diagram and any consent, any authorizing documents like a special power of attorney and any resolution that might have been enacted by trustees or directors or shareholders and the like, or members of a close corporation. Are we good so far? Now, let's talk about, we've talked about registering a bond over the notarial lease, and if there is a bond over the movable property over which we are going to register a notarial lease. When we're cancelling, we need consent of the bondholder. When we are registering, we do not need it because we are increasing the rights of the owner here with a real right. So when we're reducing the rights, we always need consent. Good people, I know we are going until 9, we're going on until 9 o'clock, so please bear with me. There is still quite a bit I need to talk to you about with regards to leases. I want you to read for next week's lecture. I'm going to try and start bonds, but I would prefer not to interrupt the lecture in respect of bonds. We might have to make up about another half an hour. Either we will do it next week on Thursday when and extend the lecture to 9 o'clock. Alternatively, we will find another time. It all depends on whether or not we have load shedding. And I've got load shedding, especially, not you guys. And you guys as well. I mean, I don't want you not to do anything. So remember what it is. Now, before I forget, so a long-term lease, hypothecated, in other words, you may register a mortgage bond over it because it is a real right. You may register a notarial bond, a short-term lease, a normal lease. It's not a real right. But we will talk about that next week. That's in terms of Section 81 of the Registries Act. Please look at Section 77, 78 of the Deeds Registries Act, 8081. It deals with a whole lot of issues. Now, in the notes, we talked to you about stamp duty. And I need to just quickly delve into stamp duty. You're going to say, repealed. Yes, I know. But what happens if a lease comes in front of you, a lease that has not yet been registered and was executed at the time when stamp duty was applicable? You will have to go out there, go to SARS and have it stamped and pay the penalties and the like. Otherwise, the deeds office will not register it because they will look at the date when it was executed and they can say, stamp duty was applicable then. So you need to ensure that you know that. We're mentioning it. I doubt that you'll come across anything purely because you register long-term leases as quickly as possible. I want to give you an example of a long-term lease and the beauty of it and how secure the lessee is and what happens. Now, in Bruma, there was a development. They created a lake. There was a river running through. They've now uncreated the lake and restored the river again. But there was a river and a whole lot of little developments, townhouse developments in amongst a beautiful forest, and they took that all down. But what they did is they created the lake, and they created on one side this little complex with all these little restaurants, and on the other side of the lake they had 2 stores. One was game, and I think one was spa, I can't remember. But what happened is that the owner of the property entered into an agreement of lease with game for 20 years. And when they saw, and it was registered against the title deed of the property, and when the owner of the property saw how well, and it was one of the big insurance, long-term insurers, life insurance, I won't mention names, but when they saw that this was working well and they had done other developments similar to this in Randburg, they wanted to extend the development right around the lake. And they said to Game, right, let's cancel your lease. So Game says, sorry guys, we've got, I think they had another 10 years in the lease. We are not budging an inch. And they could not get them out no matter what they did. So the moral of the story is your leasee has a very, very strong position when you register a long-term lease. So just to give you an example, that is the best example I can think of a long-term lease in a modern urban area as opposed to an agricultural area. Now, talking about an agricultural area, let's quickly go to farms again and agricultural holdings. We have issues with farms because we said there is an act called Subdivision of Agricultural Land Act. All right, 70 of 1970 repealed, but repeal has not been promulgated. And that, unfortunately, deals with farms. And what does this happy piece of legislation states? It says, remember, we've now just dealt with a portion of land and you need diagrams. It says that no longer into for a portion of agricultural land without the consent of the Minister of Agriculture first be and obtained in writing. So if you're leasing a portion of agricultural land, you need the consent of the Minister of Agriculture in writing. So what do you have to lodge at the deeds office for a farm? You have to lodge ministerial consent. And this consent you need to keep a copy of in your protocol together with the minute and the diagram. So here we go. And if your parties, either of your parties, according to the laws of another country, you would need the consent of the spouse when you're entering into the agreement. So these consents start mounting. These are the little things you need to know and you will need to sort out and be cognizant of and aware of. So that is the Deeds Registries Act. Now let's talk about the Sectional Titles Act. Sectional Titles Act 95 of 1986 has been amended quite a considerable number of times. Now, if you have a section, do you need to worry about the Sectional Titles Act in order to register these? No. But let's talk about what a sectional title unit is all about so that you can understand what type of leases we can enter into. A sectional title is full ownership, but there are certain limitations to your rights and you have to share properties. So you have common driveways, you have a common swimming pool, you have an entrance gate, you share walls and roofs, all right? one roof over a house that has been divided into two, you share a common wall. So normally a sectional register is made up of two registers. The one register has all the diagrams, and the other register deals with the title deeds of the property and various other consents and documents you have to obtain for purposes of opening a sectional title register. Now, you have diagrams, any development that you want to register. Any sectional title development that you register has certain diagrams. What are your diagrams? You have diagrams for each floor. One of the diagram delineates all the units as well as the common property. And then in addition to that, you have common property, you have the units, which is usually the house or the flat or whatever the case might be, and you have exclusive use areas. Now, exclusive use areas you will see when we deal with servitudes next week. So you have to read servitudes for me, please. And if you do have your notes, and I sincerely hope you have your notes, and I'm sure you will have your notes next week, in addition to reading the notes, you must look at all the annexures in respect of servitudes. Those are essential. The servitude annexure is very short. I mean, the servitude module is very short, but it is the annexures that are essential because they show you how to draft and it give you examples of everything. Some of our copies are not the best of copies, but you will see I'm going to go through great detail when we deal with servitudes. It's essential. You can get up to 2 questions, even 3 questions with servitudes. So, sectional title scheme is made up of common property, made up of the units, and it's made up of exclusive use areas. As an owner of a unit in a sectional title scheme, you own the unit, you own your exclusive use area, and you own a proportionate share, an unproportionate share in the common property, which is made up of your percentage of your unit over the whole of it. Okay, it comes up to a total of 100%. Now, why am I telling you this? You need to understand this in order to understand what we're going to be dealing with now. A sectional title scheme, once the register is opened, creates a body corporate. Our body corporate is each owner is a member of the body corporate. The owners choose trustees to run the body corporate, to run the daily business of the body corporate, to arrange, to appoint managing agents, to pay accounts, and to do all sorts of things. You appoint some trustees, and the trustees will appoint a chairperson, and the chairperson will run the meetings of the trustees, and once a year you have an annual general meeting, and if there is an urgent matter, you have a special general meeting, and you get the consent of everybody. Now, leasing your unit in your exclusive use area, or only your exclusive use area, or only your unit is fine. You can register a long-term lease over it. You're the owner, you can do as you please, obviously subject there's compliance with the rules of the body corporate. But the body corporate may lease a part of the common property. In order to do so, you have to have unanimous agreement by all the owners. And there is a resolution in which the owners agree and authorize the trustees to lease out property to let to a lessee for 10 years, 15 years, part of the common property. You would need a diagram for that part of the common property. You would need the resolution. And I will send you an example of a question to help guide you on how to draft it. So when we describe the common property, when we describe the body corporate and its property, we describe it slightly differently. what I want you to, we don't have a sectional section, but what I want to bring to your attention is the various sections that deal with this. It isn't just one or two. The Sectional Titles Act has very similar sections to it as the Deeds Registries Act. The Deeds Registries Act, however, is far more extensive. Here we're just dealing with sectional title developments. Section 15, subsection 7 of the Act provides, Section 15, that the registrar shall not register a notarial lease or notarial sublease unless such lease or sublease is accompanied by a certificate. All right, forget that. That talks about stamp duty. My apologies, it's the wrong one. Section 17, subsection 1 says that the owners may, by unanimous resolution, direct the body corporate on their behalf to alienate common property or to let common property or any part thereof under a lease. So section 17 is the empowering clause, that it needs to be done by unanimous resolution if you're dealing with the common property. All right. There isn't really that much more I need to tell you, except for descriptions. What I'm going to do to make it easier is I think tomorrow, mail all of you in my email that attaches all the other documents. I will send you an example of how you word a description of the leased property, the leased common property. All right. So you do not have to worry about remembering what I tell you now, just to make it easier for you. Now, please do not forget what we talked about for the subject matter of the lease. What happens on termination of the lease? What do we have to do at the deeds office? Well, a lease will terminate when the period expires, obviously. And it can also terminate on the occurrence of a specific event taking place. So it might have been specified. If it is terminated prior to the expiry of the lease period, then there must be a mutual agreement between the parties, and we'll do a consent to cancellation executed notarially. Okay. Now, death of a lessor should not terminate your lease agreement. Remember what we discussed. It is effective if it's registered against the title deed of the property, against the heirs of the lessor or the lessor's successors in title. So that would not terminate it. We talk about insolvency once again, a favorite topic. Does that necessarily affect a lease agreement and terminates the agreement of lease? Well, it would depend on the circumstances, obviously. So I don't think so. Remember, we have registered the lease in the first place. It's to protect the lessee from the lessor's creditors. So, good people, please bear that in mind. I'm not going to be that much longer. Bottom line, I need you to have a look. Wait, before I forget. When you're cancelling, or when you've got a deed of cancellation, or when it's terminated by fluxion of time, what do you need to lodge at the deeds office? You will need to lodge the original agreement of lease. You will need to lodge the title deed of the property. Now you're reducing rights. If there's a bond registered over the property, you will need to lodge the consent of the bond holder. And that's really it. You don't need anything else. What else do I want to tell you about leases? I think that is really about it. The only item I need to bring to your attention is if you are leasing common property in a sectional title development, and that probably would be a weird one. you need to remember that there are certain, I hate to say this, but there are certain sectional title developments that, for some strange reason or the other, have been developed on farmland, with the consent of the Minister of Agriculture, I might add, in which case, if it's a sectional title development on farmland, I want you to think about this. Would you need ministerial consent? Having mentioned this, of course, you would need ministerial consent, because although it's a sectional title development, it's not an urban property, it's a farm property, and it falls under the prohibition of leasing a portion of farm property without the consent of the Minister of Agriculture. Please think about it, and I will give you a different answer. We will talk about it again next week. We really need to cover that issue. Now, may I start on notarial bonds very quickly, if you don't mind? What I want to do is I want to just briefly remind you where all the information we have comes from in respect of notarial bonds. In the Deeds Registries Act, we talk about mortgage bonds and we talk about notarial bonds as well. So the mortgage bond is over immovable property. A notarial bond will be registered, it is registered, and it deals with movable property as security. So a mortgage bond, they are all underlying contracts. They usually are loans. The underlying contracts are usually loans of funds and similar things. I don't want to just go into that detail, but a mortgage bond is in relation to a loan, and you're securing the loan by means of registering a bond over immovable property. A notarial bond secures usually a loan by registration of a bond where the security provided is over mortgages. Okay, so that is the biggest difference between mortgage bonds and notarial bonds. For the sake of ease of reference, when we are referring to the creditor and the debtor in a bond, we refer to them, the creditor as the mortgagee and the debtor as the mortgagor. You're going to say, but that is the reference we make to them as a mortgage bond. It doesn't matter. This is the reference we're making to them. So I'm just covering the basics now. I'm not going to talk about mortgage bonds. I'm just talking about terminology and where we find all of this. A bond is basically an agreement entered into, and we register bonds to secure an obligation on the part of a debtor towards a creditor. And that is to ensure the repayment of money lent to the debtor by the creditor, effectively. All right. So mortgage bonds in general are referred to in the Deeds Registries Act in terms of Section 61 and 62. And I will go through everything with you, so please don't worry. I will go through it next week. So don't have heart attacks, please. We have general provisions for mortgage bonds and notarial bonds. All these sections in the deeds refer to both. When they specifically refer to a notarial bond, there's an exception. They will set it out. I am going to go through all of them. I do not want you to stress about notarial bonds or mortgage bonds either. If you are doing the conveyancing course, the same applies to mortgage bonds as does to notarial bonds. The only thing with notarial bonds is they are executed before a notary, and a notary attests to them, whereas a mortgage gets registered, it gets executed by the debtor, the mortgagor, and gets registered at the deeds office. With a notarial bond, it gets executed by the mortgagor before the notary, and then it gets registered at the deeds office. Okay, So that is the only difference we have. And of course, the fact that the one is providing security, the security is immovable property, and the other one, the notarial bond, the security is movable property. Please do not forget that. Now, I need to tell you, I do not want you to feel that bonds are difficult. Yes, you're going to have to learn certain things off by heart. However, it is one of the easiest topics that we will be dealing with. Well, relatively easy topic. Once you understand the different types of bonds that we have, and this is the same for mortgage bonds as it is for notarial bonds. So for those of you who are doing conveyancing, please bear with us. Some of the information we're going to deal with, you have already dealt with or you are going to deal with soon. It's going to help you in both courses. Once you understand how to identify what it is you are being asked, you have won half your battle. You've already identified the kind of bond that you're going to be drafting, and you will then proceed accordingly. Yes, the causa, which is the reason for the bond, and the manner in which you have to describe your causa is annoying. You're going to have to learn that off by heart. But there is a way and means of actually curtailing how much you have to learn off by heart. So, do not think this is a difficult hill to cross. It's not insurmountable. It's actually a little bump as opposed to a hill or a mountain. It's easy. Once you've listened to what I've told you and you follow what I tell you, it is one of the easier topics to deal with in the exam. You always get a bond in the exam. You might even get more than one question, whether it is short questions, long questions. We're going to deal with the general information. We're also going to prepare you next week for short questions so that you don't have any problems. The Act is important because it tells you what you can and can't do, all right, with bonds. That is the importance of the Act, and obviously other than empowering you to register, but that is our situation. Bonds are not difficult, and I will show you next week exactly how you are going to overcome the issue. So do not have any problems with this. Do not feel that it is insurmountable. It actually is not such a difficult topic. And if you work out a system, and I'm hoping to show you that system, it will make life easier when you're studying it. Okay, good people. I'm sorry I could not finish bonds, but please understand it is an important topic. I do not want to actually get into the main topic. I want to do it all together. So next week we will do notarial bonds and we will do servitudes. You are going to prepare for those. Please read through the annexures for both bonds. Well, you don't have to worry too much about bonds. You can read the annexures afterwards for bonds. I'd like you to look at the annexures for servitudes. If you can't, that's also fine. You can do it after we finish the lecture. But I do want you to work on assignment 2. I'm going to send you the model answers for assignment 1. I'm also going to send you assignments 3 and 4 so that you have them. Those of you who do not receive anything, send me an email. It's litsasky@mweb.co.za. Do not forget, send me an email if you have not received anything by Monday morning or tomorrow afternoon. I think we have load shedding tomorrow afternoon, but send me an email if you haven't got an email from me. I haven't had any returns on your email addresses, so I think we're fine and you've all received my emails. The other thing I'm going to do next week, I'm going to send you some more questions that I think you need to look at and that we will try and look at either in the catch-up lecture or last lecture. I am now going to sign off. Thank you so very, very much for sitting this extra half an hour with me so we could try and make up some of the time that we lost last week. And I hope you enjoyed the lecture. We're going to have great fun next week because I do like both the topics even more than all of these other topics we dealt with. As I said, you have to do everything. Everything's going to be in the exam. This is not a difficult course as such. There is a lot of information that you need to know, and there's drafting that you need to do. So practice, write out the questions, answers to the questions. We're going to send you more questions. Have a very good evening, everybody. I'm going to stop recording now, and all of the very best, and see you next week. Let's keep our fingers crossed and hope we do not have any power failures. Have a good night. Bye.